Child marriage is a social scourge and we are committed to ensure this evil practice is stopped. This is what Assam Chief Minister Hemanta Biswa Sarma tweeted last Friday. Since 3rd February, Assam has seen thousands being arrested as a part of the state's crackdown on child marriages. In fact, in the last 2 weeks, the Assam police has arrested 3,047 people in this crackdown. It has registered 4,235 cases and has identified at least 6,707 accused so far. And those arrested have been booked under the Protection of Children from Sexual Offences Act 2012 or the POCSO Act and the Prohibition of Child Marriage Act 2006 or PCMA. And according to reports, the state cabinet has resolved to book men who have married girls below 14 years of age under the POCSO Act and those have married girls in the 14 to 18 age group under the PCMA. However, critics have alleged that the crackdown has a communal design and is directed against the religious minorities. Naturally, the law has reignited the debate on uncertainty over the legal age of marriage for Muslim women. What does the Muslim personal law say on the age of marriage and who determines the age of puberty? Does the Protection of Child Marriage Act apply to Muslim marriages and what have courts said about this? I'll answer all of these questions for you in this video. Now here's what the law says. The PCMA or the Prohibition of Child Marriage Act 2006 makes it an offense to promote or permit child marriages. So it makes it a crime if a parent or a guardian promotes or permits or even negligently fails to prevent or attends or participates in a child marriage. As per this law, a child or a minor is a girl aged less than 18 years and a boy aged less than 21 years. So those are the age limits that the law places on marriages, meaning that these are the legal ages to marry. For a woman, it's 18 years. For a man, it's 21 years. In case a child marriage does happen, the law allows a petition to be filed to declare the marriage void once the child becomes a major, but such a petition needs to be filed within 2 years of the child attaining majority. There's another law in the mix here, which is the POCSO Act 2012. This law was brought in to protect children from offences of sexual assault, sexual harassment and pornography. And the law criminalizes all sexual acts amongst those under 18 years of age, regardless of whether consent is present or not. So in other words, this law, that is POCSO Act, defines a child as someone below the age of 18 years and does not recognize their consent as valid at all. Now, sexual assault under POCSO is a non-bailable and cognizable offense, which essentially means that the police can make an arrest under this law without a warrant. So now, since this is clear, the law part is clear, let's talk about Muslim personal law. Basically, as per Muslim personal law, and I quote, every Mohammedan of sound mind who has attained puberty, unquote, can marry. And it adds that when there is no evidence, puberty is presumed on the completion of age of 15 years. However, the marriage is considered void if a Muslim of a sound mind and who has attained puberty is married off without their consent. Therefore, Muslims above 15 years of age can enter into a legal marriage as per their personal law. However, it's this gap between Muslim personal law on one hand and laws like POCSO and PCMA prescribing a cutoff date of 18 years for marriage and sexual activity that has created uncertainty over the legality of marriages under Muslim personal law. And the confusion continues because several high courts have since given conflicting judgments on what this legal age for marriage for Muslims should be. So, for example, the Karnataka High Court and the Gujarat High Court both have held that in cases of minor Muslim girls, the 2006 law, that is the PCMA Act, will prevail over the provisions of Muslim personal laws, meaning they say that even amongst Muslims, 18 years is the legal age for marriage. The Gujarat High Court also ruled in 2015 that the PCMA was a special act and it will override the provisions of Muslim personal law, Hindu Marriage Act or any other personal law for that matter. Last year in November, the Kerala High Court also stepped in and ruled that marriage between Muslims under personal law is not excluded from the sweep of POCSO Act. The court asserted that, and I quote, if one of the parties to a marriage is a minor, irrespective of the validity or otherwise of the marriage, offences under the POCSO Act will apply. unquote. However, the Punjab and Haryana High Court ruled in 2018 that the provisions of the Muslim personal law would prevail over provisions of the PCMA. So it therefore ruled that puberty and majority in the Muslim law are the same thing, and that a boy or girl who has attained puberty is at liberty to marry anyone he or she likes, and the guardian has no right to interfere. And this isn't just one example coming from the Punjab and Haryana High Court. This High Court has delivered several such judgments over the past few years. In fact, this is what has now taken the issue to the Supreme Court. So the matter reached the Supreme Court after an order passed by the Punjab and Haryana High Court in September 2022, that is last year, was challenged by the National Commission for Protection of Child Rights, which is NCPCR. The High Court was hearing a habeas corpus petition filed by a 26-year-old man against the detention of his 16-year-old wife in a children's home in Panchkula. Relying on Muslim personal law, the High Court had directed her to be released. The children's home was then asked to hand over her custody to her husband. So referring to this order last month, the Supreme Court said that the High Court judgment, this particular judgment, should not be relied upon as a precedent in any other case. The bench passed the interim order while issuing a notice on the NCPCR petition, which alleges that the High Court judgment goes against the POCSO Act, which, like I told you, prescribes 18 years as the age for sexual consent. The NCPCR has filed a similar petition in the Supreme Court, again challenging another order passed by the Punjab and Haryana High Court. This order was passed in June last year, granting protection to a 16-year-old girl and a 21-year-old boy. Both of them were married according to Muslim rites and ceremonies. The Supreme Court issued notice on this petition in October last year while appointing senior advocate Raj Shekhar Rao as amicus curiae. Similar petitions have also been filed by the National Commission for Women. A total of 5 such petitions have been clubbed together and will be heard by the Supreme Court anytime now. In the meantime, just to let you know, the Guwahati High Court has questioned the application of POCSO Act in the child marriage cases in Assam while it was hearing anticipatory bail pleas. These petitions were filed by people apprehending arrest in one such child marriage case. This was on 14th February. Several similar matters came up before the court the same day on 14th February. So in another such case, the court asserted that these are not matters for custodial interrogation. The court also said, and I quote, "It is causing havoc in the private life of people. There are children, there are family members and old people," unquote. So this is where the issue stands right now. Assam continues its crackdown on child marriages, and in the meantime, the Supreme Court is set to decide whether a special law like Prohibition of Child Marriage Act would prevail over Muslim personal law. Thank you for tuning in. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.